Um, okay, let's do. Speaking of not protected First Amendment rights, Cuties. I'm not even going to ask if you've watched it because my first question is going to be if it is deemed to be child pornography. Is not everybody who tweets and retweets it committing a breach? But before we get there, for anybody who doesn't know, Cuties is a Netflix movie. It's a movie that's being aired on Netflix. It's a French movie. The movie's called Mignonne in French. It's the story of 11-year-old girls coming of age in a world of hypersexualized prepubescent girls on social media. The main character comes from a Muslim family with traditional, I would say they're only Muslim values, traditional values that do not look kindly on hypersexualizing young girls on social media. There are some there's some content in that movie that is itself questionable, to put it mildly. Everyone's been tweeting about it for the last 2 days to the point where people are saying, if you're tweeting the offensive, shocking parts, you're sort of contributing to the problem. Tulsi Gabbard came out and said this is CP. We'll just call it that throughout the rest of the stream. It's terrible. It's potentially criminal. Tom Cotton comes out, says the same thing. Ted Cruz writes a letter to Attorney General Barr, asking him to look into it. Did they break federal laws? I guess I didn't miss any details. Starting from there, Robert, I mean, I didn't get into this in my video that I put out today. Canadian CP laws are even stricter than the U.S., but they're pretty much on, they're quite strict in the U.S. nonetheless. From what you've seen, is there a plausible argument that this actually violates federal law?
Probably not. And I think it's because people are confusing the word simulated in the statute. So for pornography in general, there's a constitutional limitation if it's adult people that are being featured. Because in that context, it's whether or not it's obscene under the First Amendment. I saw people trying to do an artistic analysis. That doesn't apply if it's children. Any pornography involving children is illegal in the United States, period, and not protected at all by the First Amendment. Only pornography involving adults can be if it meets certain artistic standards such that the court no longer calls it obscene. Unfortunately, that's where our legal standard famously comes from, the statement of the Supreme Court Justice who said obscenity is, I know it when I see it. That's what it is. That's not the greatest legal standard ever articulated. So that's the first part, is that if it is pornography involving children, it is unconstitutional, period. It's not constitutionally protected. So the question becomes, what does the statute define? Now, there's probably some constitutional constraints on what the statute can define, and those it has to actually be pornography. That has always required graphic behavior, the depiction of graphic behavior that usually requires either nudity or the sex act itself, or the simulated sex act, not someone doing a dance routine. So the first time this came up was Britney Spears. Is the last time I remember this debate coming up legally. People should go back and, well, I don't recommend watching it, but when she was 15, she was doing things that are there. I didn't watch this either, so I'm not commenting from a place of knowledge. I can't watch things like this. The same with, I remember years ago, someone recommended I go into becoming an FBI profiler, someone that had connections to that world for serial killers. And I was like, I can't stay inside a serial killer's head for days. That will drive me insane. Might be good at it, but don't want to do it. Same with child pornography. I just can't deal with it. I always referred those cases out where someone has an issue there. So I'm not going to watch the film. I've heard the defense of the film. The defense of the film is that it's trying to be critical of this by depicting it. I've always had a problem with that. I don't think it's well. I think there's ways you could talk about how it's being portrayed without actually portraying it. I think it's a problem to actually portray it. But what they're portraying by our legal definition does not meet the definition of a crime in the United States, because what needs to be simulated is an actual act between two people and things of that nature, or nudity that can be seen in a lascivious manner. These dance routines from the Britney Spears days are not considered a violation of the law, and there probably would be some constitutional questions at that point, because it does not meet the historic definition of pornography that's outside the protection of the First Amendment.
But so, and I mean, I was looking through the federal statutes that Ted Cruz listed in his letter, not knowing anything more. Under the definition of sexually explicit conduct, it said real or imitate, basically real or simulated. One of them was masturbation. So, I mean, I have not watched the movie either. I'm not going to watch it. I have no interest in watching it. I know the plot and I know the message, and it's great. I don't think you need to use 11-year-old girls to make that message. Sort of like abusing an animal to show why animal abuse is bad. It's right. Counter. It's illogical. But the statute under sexually explicit refers to masturbation. Part of the dance, arguably, if not arguably, shows hands on crotch. And part of the statute also says sexually explicit is focusing on the groin or anal region, which I think, that dance scene in particular, arguably or not arguably, focused on. And so the question
they would need nudity. And it was for that form of simulation to be pornography under the law, they need nudity to be attached. So they simply wanted to make sure under the statute that when you're depicting a sexual act, that if the sexual act itself did not occur, you could still consider it pornography. But in that context, you need nudity for it to occur. So there are circumstances where you can have a simulated act and not have nudity, but it needs to be a truly simulated act. For that one, you would need nudity for it to be considered a crime of pornography under the statute.
All right, now in case anybody else's head out there is exploding, there people are going to say what they were doing, when they were gyrating on the floor was a simulated act, maybe more graphic and more explicit than, hands on the groin.
But without nudity, it wouldn't be a crime under the law.
Okay, that's interesting. I mean, it was not knowing anymore. I think in Canada we're getting very close to what might be recognized because we've had even more peculiar cases that had been recognized, overturned on some cases. There was an artist who had hand drawings, or they were sketches that were recognized as child pornography, overturned on appeal. There was another situation where an individual had images which were indisputably CP, but also had short stories that the person was writing to themselves. And that portion of it was deemed to be an exception because it was private writings for his own personal consumption. So we've had extreme cases of severe application of the law and carve-outs that didn't apply in this case. But a lot of people, myself included, are thinking what they were doing with their hands, what they were doing on the floor for 11-year-old girls, sounds like it qualifies as child pornography under the statute as defined, but I mean, if not, then not. Another question. I mean, what about are there child exploitation laws that might apply to this particular movie?
Probably not. I mean, to my knowledge, they filmed it in France. So unless so there wouldn't be U.S. laws that would necessarily apply. There's certain sexual trafficking laws that apply internationally, but not labor exploitation laws generally require a U.S. jurisdictional nexus to the actual performance of the labor, not just the display of the film. Now, child pornography can be made anywhere and it be considered illegal. And the way I look at it is, could they expand the statute to include this? And I think Jonathan Turley is probably right that would probably raise some constitutional questions. That historically it's always been the explicitness of the behavior that has been banned, and it was always debated whether simulated behavior should be banned. Also, early constitutional challenges to child pornography laws included fake images. So the fake images are common in the child pornography world. And they said, no, that can in fact be banned. So you don't have to have an actual display of actual sexual behavior in order to it be considered child pornography. But they've limited the scope to where simulation can go such that it doesn't reach things like what I always called it the Britney Spears of the world. So that was considered excluded from the definition of child pornography, such that even if it's suggestive, it's not a simulated sexual act. So basically simulated sexual act is meant to be that you believe they're actually engaged in the sexual act in a graphic way. That's the idea. So that there's some form of genitalia or something like that being actually displayed, or you think it is. And they use simulated to just get at situations where they're pretending the act is taking place, but they're convincing you it's actually taking place when in fact it's not. If you understand that, what people are thinking of when they think of simulated is they think of suggestive. And as they're looking at something and saying this person is imitating a sexual act, they're trying to be suggestive of a sexual act. That has never been a crime, and it'd probably be issues with making it a crime. Is my best guess. I understand why the public outrage is present, of course, and in the context of California passing crazy laws that are expanding, are intended to basically functionally lower the age of consent, raises people's moral outrage is absolutely justified. But right now, given the way the laws are written and given the constitutional concerns with how that language is used, it's unlikely that what's portrayed in the film would ever be against the law in the United States. I think it may violate the law of other countries that have stricter regimes and don't have the same constitutional constraints on films like this.
Yeah, I mean, and one example, just in terms of simulating masturbation, someone doing the gesture with their hand is simulated masturbation, whether or not it's explicit enough. So, I mean, these were some of the thoughts that I had in terms of if they are in fact going to qualify this as, potentially or bona fide child pornography in the States. There's a whole bunch of other problems in terms of what's on TikTok, who's sharing videos like that on TikTok.
Anybody who possessed the film could be prosecuted. I mean, that's the other reason why that it won't ever happen. They will never define this film as child pornography here. And my guess is it was legally cleared by people before it ever went up on Netflix in the United States.
Someone had raised the point, though. There apparently, again, I haven't watched it and I don't know, but apparently there was not a topless scene, but rather an exposed breast of a child in the movie.
Oh, I did read about that. They say that's in what it is there's a description about nudity being in the movie, but it's not of a child.
Okay.
Because that would be problematic
if they were to show, but then it gets into the question of you have the diaper ad where you have exposed kids, but
that's okay because it's not lascivious. That's the other component. So nudity combined with lascivious sexual suggestiveness constitutes child pornography.